Welcome, ladies and gentlemen, to another segment of Whether or Not. I am Alexa.
I am Rose. For tonight's episode, we will be talking about the famous case of the island of Palmas, a dispute between the Netherlands versus the United States of America back in 1928. Without further ado, let's roll the clip.
Palmas, also referred to as Miangas, is an island about 2 miles long by 3/4 of a mile wide, which at the time of this case had a population of 750 and was of little strategic or economic value. It sits about halfway between the islands of Mindanao in the Philippines and Nusa in the Netherlands Indies. It is, however, within the boundaries of the Philippines as defined by Spain. In 1906, an American general, Leonard Wood, visited Palmas and discovered that the Netherlands also claimed sovereignty over the island. Both states laid claim to the ownership of the island of Palmas. While the United States maintained that it was part of the Philippines, the Netherlands claimed it as their own. The claim of the United States was backed up with the fact that the islands had been ceded by Spain by the Treaty of Paris in 1898, and as successor to the rights of Spain over the Philippines, it based its claim of title in the first place on discovery. On the part of the Netherlands, they claimed to have possessed and exercised rights of sovereignty over the island from 1677 or earlier to the present. An agreement was signed on January 23, 1925 between the United States and the Netherlands to submit the dispute to binding arbitration. The Swiss jurist Max Huber was the selected arbitrator acting for the Permanent Court of Arbitration. Huber was charged to determine whether the island of Palmas or Miangas in its entirety forms a part of territory belonging to the United States of America or of Netherlands territory.
At issue in this case was the sovereignty over a small island with around 700 inhabitants called the Island of Palmas, or the Island of Miangas, the north of the archipelago which today constitutes Indonesia. We have a special guest tonight, Mr. Max Huber, the then president of the Permanent Court of International Justice, a sole arbitrator of a tribunal set up under the auspices of Permanent Court of Arbitration. It was agreed that the sole duty as the arbitrator shall be to determine whether the island of Palmas, in its entirety, forms a part of territory belonging to the United States of America or of the Netherlands territory. Now help me give an enthusiastic welcome to Mr. Max Huber. Good evening, Mr. Huber.
Good evening. I'm happy and honored to be here.
First, the award establishes that state sovereignty signifies independence and exclusive competence, such that in international law, sovereignty is the point of departure in settling most questions that concern international relations. It follows that appeals to sovereignty for the settlement of legal disputes must be accompanied by careful examinations of what exactly sovereignty signifies. Sovereignty in the relations between states signifies independence. Independence in regard to a portion of the globe is the right to exercise therein, to the exclusion of any other state, the functions of a state. So the development of the national organization of states during the last few centuries, and as a corollary, the development of international law, have established this principle of the exclusive competence of the state in regard to its own territory in such a way as to make it the point of departure in settling most questions that concern international relations.
Island of Palmas makes plain that with sovereignty, as that concept is understood in international law, comes not only certain rights and freedoms from states, but also obligations. Thus, in Island of Palmas, sovereignty involves not merely the exclusive right to engage in the activities of a state within a given territory, but also, as a corollary, the obligation to protect within the territory the rights of nationals and of other states. Mr. Huber, how would you define territorial sovereignty?
Territorial sovereignty cannot limit itself to its negative side to exclude the activities of other states, for it serves to divide between nations the space upon which human activities are employed, in order to assure them at all points the minimum protection of which international law is the guardian. I would also like to point out the importance of the activities of the state vis-a-vis the individuals living on the territory over which the state claims to have sovereignty. In Island of Palmas, when stressing the importance of peaceful, continuous, and effective display of state activity as a title of acquisition of sovereignty, expressed the view that the recognition of the effect of prescription is necessary in view of the particular needs of international society.
Now, as to intertemporal law, the island of Palmas establishes that a juridical fact must be appreciated in the light of the law contemporary with it. So, nonetheless, the same principle which subjects the act creative of a right to the law enforced at the time the right arises demands that the existence of the right, in other words, its continued manifestations, shall follow the conditions required by the evolution of law. In Luther's words, Island of Palmas gave expression to the rule generally recognized in domestic law that legal situations come into being validly in accordance with rules that are in operation at a certain given point in time, but depend for their continued existence on rules which later come into existence. Now, as the sole arbitrator, Max Huber explicitly tempered the second lib of its test by adding the rider that the second lib will not be brought to bear in the case of territories in which there is already an established order of things. Now, as Crawford would later observe, the two elements of the island of Palmas case are less antithetical than they may seem. First, stability due to the creation, and second, flexibility due to evolution in the existence of rights. It should be conceived as a complementary principles. So the two-linked principle of intertemporality was not a new one. Early arbitration settled on the heels of the gradual development of the customary rules concerning discovery and occupation showed that the gradual evolution of international law in respect of the acquisition of sovereignty from the original legal sufficiency of discovery or symbolic occupation rather to the requirement of the effectiveness of the occupation itself. So the principle of intertemporality was most famously criticized by Hesse. He attempted in his criticism to take the axe to the very root of the ruling in the Island of Palmas case, for him, the effects of which he saw as highly disturbing. So, to further support his criticism, let's roll a clip.
Assume that State A in a certain year acquires Island X from State B by a treaty of peace after a war in which A is the victor. Assume Island X is a barren rocky place uninhabited and desired by A only for strategic reasons to prevent its fortification by another power. Assume that A holds Island X but without making direct use of it for 200 years. At the end of that time, suppose that the development of international morality has so far progressed as to change the previous rule of international law, and that the new rule is that no territory may be acquired by a victor from a vanquished at the close of a war. Under the theory of intertemporal law, as expounded, it would appear that A would no longer have good title to Island X but must secure a new title upon some other basis or in accordance with the new rule. Such a retroactive effect of law would be highly disturbing.
What can you say about this, Mr. Huber?
The argument put up forward by Gisop and his example is open to criticism. First, Gisop's case in point is different from the legal situation in Island of Palmas. While the norm I relied on related only to the facts obtaining at the time of the coming into force of the norm itself, the norm in Gisop's example bears on the way in which the territory was acquired in the first place. Thus, A's right to Island X in Gisop's example could be extinguished only if it was applied to the acquisition which took place 200 years before the norm's coming into force. This was, however, exactly that which the tribunal was at pains to avoid in Island of Palmas. It made very clear that the effects of the new rule was that discovery alone, without the subsequent act, cannot at the present time suffice to prove sovereignty over the island of Palmas. It is thus far from clear that the effect here described is actually retroactive. Rather, the case is that the change of law prompts a change of ex nunc as opposed to ex tunc. This has parenthetically led one commentator to argue not only that GSAP had misunderstood the difference between nullity ex nunc and ex tunc, but also that his was an outright misreading of the whole Island of Palmas case. In the light of the above, this criticism of GSAP's stance seems fair. Secondly, counterexamples to GSAP's example could be imagined that would make very clear the necessity of the role of intertemporality. One could think of examples bearing on colonialism. It could hardly be disputed that colonialism was central to the development of international law. It is possible, therefore, to imagine examples to do with slavery, exploitation, and the rights of people to self determination, which would furnish us with situations in which was once in conformity with international law at a later point is singularly in breach of a newly emerged rule because, to use Setup's words, the development of international morality has so far progressed as to change the previous role of international law. There is this twofold misconception. First, the new norm did not, in point of fact, reopen the question of the title acquired at the date of colonization. It rather demanded its cessation and just possibly eroded it. Secondly, the new norm did not operate on the basis of re examining old titles, but based itself on the rights of the inhabitants of the colonially defined territory to self determination. A third criticism leveled at the principle relied on by the tribunal in Island of Palmas by Jessup was that the application of my principle would mean chaos if such a principle were to be applied to private law and private titles in national law. The intertemporal law, like other branches of international law, does not operate in a vacuum. Rather, it operates in relation to facts and in the context of a wider framework of legal rules of which it forms only a part. The impact of intemporal law will be reduced by the effect of other principles of international law. This includes the effect of recognition, acquiescence, and the role that abandonment is not to be presumed. The principle of the island of Palmas rule has become an article of faith in international law. Yet the chaos foreshadowed by Jesus seems somehow not to have come to pass. This is partly because of the flexibility of the rule. It is also partly because other principles of interpretation and application of intertemporal law, such as acquiescence, prescription, and desuetude, would operate to make it impossible for the second element of the principle to work injustices. But the success of the principle is also precisely the fact that it reflects the evolution of law. There is no surprise in the fact that the states follow international law, for it is the states themselves who will have made the law which they are following. The reason why states do comply and always have complied with international law is that they make the rules to suit themselves. The intertemporal principle to which Island of Palmas gives expression has taken on importance within treaty interpretation.
Two other issues were settled by the award. First, as the International Court observed in land and maritime boundary, the award is authority for the proposition that agreements between states and local chieftains are not treaties. The court referring to arbitrator Huber's determination that such an instrument is not an agreement between equals. It is rather a form of internal organization of a colonial territory on the basis of autonomy of the natives. As Judge Alcasaone pointed out in his separate opinion, however, Island of Palmas was on this score clearly wrong. The fact that the agreement is not one between equals does not mean that it cannot be valid as a matter of law of treaties. Judge Alcasaone observed that such an approach is a confusion of inequality in status on one hand and inequality in power on the other. The local rulers and chiefs were weak in apparent for their agreeing to enter into treaties of protection, but this does not detract from the fact that they had the capacity to enter into treaty relations.
I ruled that some local political entities in Southeast Asia could not conclude real treaties because they were outside the European family of nations.
Secondly, and less controversially, the island of Palmas is authority for the evidentiary rule that maps are to be handled with great care. So what can you say about this, Mr. Huber?
Only with the greatest caution can account be taken of maps in deciding a question of sovereignty. Any maps which do not precisely indicate the political distribution of territories clearly marked as such must be rejected forthwith. The first condition required of maps that are to serve as evidence on points of law, if their geographical accuracy, it must here be pointed out that not only maps of ancient date but also modern, even official of semi-official maps seems wanting in accuracy. Though the disputed territory in question was all but minuscule, the award settling which state had sovereignty over it is nothing if not a landmark of public international law.
True, Mr. Huber, and with that, the island of Palmas is one of the first cases which made public international law a public law, as opposed to being only as one leading 19th century work would have it, private law writ large. So as the sole arbitrator, Mr. Max Huber showed private law concepts of ownership were not sufficient to inspire the international law of sovereignty over the land. The island of Palmas thus took a small but decisive step away from a conception of international law in which sovereignty had been modeled on transfer of property in domestic private law.
Small, because it was founded on already existing international law as set out in numerous awards and judgments. Important, because by leaving behind the negatively conceived private law concept of sovereignty as ownership, sole arbitrator Huber in Island of Palmas considered himself bound to conceive of sovereignty as a fundamental concrete concept, positively conceived and one which gave importance to the individuals who actually lived on the territory in question.
According to the orthodox conception of international law, individuals were classed as objects of international law on a par with rivers and canals. Island of Palmas, through the concept of sovereignty that it promulgated, effected a jurisprudential dent in this age-old conception. So in this way, the island of Palmas can be seen to have laid the groundwork for later developments of international law, which would recognize individuals as subjects and no longer only objects of international law. This should be seen as being closely connected with that which the award says about the intertemporal law. The second limb of the intertemporal rule was no more than a natural corollary to the modern doctrine, according to which sovereignty involves the provision of guarantees for the observance of minimum standards of international law in the territory. We would like to thank our special guest for tonight, Mr. Max Huber, for this fruitful discussion regarding the case of the island of Palmas.
Glad to be here.
And to answer tonight's question of whether the island of Palmas or Miangas in its entirety forms a part of territory belonging to the United States of America or of Netherlands territory, the answer is Island of Palmas belongs to the Netherlands. Once again, we thank you for watching. Have a pleasant night.